I'm Drew Stevenson, and this is for my administrative law class. Here I'm going to be talking about the case United States versus Martinez-Fuerte. This is a 1976 U.S. Supreme Court case about administrative agency inspections. So let's dive in. In this case, the U.S. Supreme Court considered criminal prosecutions that were arising from the transportation of undocumented immigrants or people who are unlawfully present in the country, where the defendants had been arrested at permanent checkpoints that were being operated by Border Patrol uh, pretty far from the international border itself inside the country. So the central question posed in this case is whether stopping a vehicle at these fixed checkpoints for brief questioning of the occupants without any particular reason to think that that vehicle contained individuals who were unlawfully present in the US and without any type of judicial warrant, whether that violated the Fourth Amendment. Back in the 1970s, the United States was facing significant challenges in stopping the flow of illegal entrants from Mexico, given the very long border shared by the two countries. And a lot of it was uninhabited or thinly populated, which made it pretty easy to sneak across the border and hard to patrol the entire border all the time and catch every one who was doing an unlawful border crossing. So as a result, the Border Patrol adopted a strategy of having these permanent checkpoints. This became really a key component in the 1970s of their inland policies and enforcement of these traffic checking operations. And these were strategically located on important roads that were leading away from the border in order to try to catch or to minimize illegal migration and to deter smugglers. In this case, the U.S. Supreme Court needed to distinguish prior cases, which it did. It differentiated these checkpoint stops for immigration purposes from previous rulings on roving patrol searches or even permanent checkpoints, roadway checkpoints, which had required probable cause, and roving patrol stops, which require reasonable suspicion. And this was because the court thought that there was a different balancing of public and private interests in this case. In this case, the court actually acknowledged that stopping a car to question the inhabitants of the people inside the vehicle is a type of seizure under the Fourth Amendment or for Fourth Amendment purposes, but they said it was really insignificant, that the requirement for individualized reasonable suspicion would be impracticable and would undermine the effectiveness of these checkpoints in deterring smuggling along major routes. So the court here used a balancing test, basically said the intrusion on motorists' Fourth Amendment interests at these roadway checkpoints and stops was really minimal. It was just brief detention, momentary, for questioning and a visual inspection without a full search. And the court said that this causes less subjective fear than, let's say, roving patrol stops where you get pulled over by the side of the road and the police really want to search your whole car. And so they thought that this wasn't that big a deal, that from time to time that they would be just stopping every car for a minute or two and asking a few questions of the people that were inside the car. So in the end, the Supreme Court held that these stops for brief questioning that are routinely conducted at located permanent checkpoints are consistent with Fourth Amendment and can be done in the absence of any individualized suspicion. There doesn't have to be any reason for the police to suspect this particular car before they stop it and ask a few questions of the driver and the occupants of the vehicle. So the court's holding in this case is that this practice of selectively referring motorists to a secondary inspection area for a routine inquiry, even based on criteria like apparent Mexican ancestry, was deemed constitutional as the overall intrusion remains minimal and the officers need wide discretion and they don't have to have any particularized reason for asking some questions of those individuals. For those of you who like to highlight or underline in your case books, I pulled out a quote that I thought was one of the major arguments or points that the court made here. The court said, accordingly, we hold that the stops and questioning at issue may be made in the absence of any individualized suspicion at reasonably located checkpoints. And they arrived at this by balancing the public interest against minor imposition on the motorists at these checkpoints. I hope you can see that Martinez-Fuerte basically established a pretty significant exception to the typical Fourth Amendment requirement of some sort of individualized suspicion. It distinguished these permanent checkpoint stops from other types of searches, like patrol searches, where the police pull someone over or stop someone on the street, and so forth, and because those usually do require reasonable suspicion. And just for good measure, the court also held that the operation of fixed checkpoints or for routine stops didn't need pre-authorization by some sort of judicial warrant or the courts. And this, again, distinguished it from cases involving searches of private residences when finding that visible manifestations of authority provide sufficient assurances. That concludes our discussion of United States versus Martinez-Fuerte. Thanks for watching.